కోనసీమ జిల్లాకి అంబేద్కర్ పేరు మార్పుపై చెలరేగిన హింసాకాండ కేసుల ఉపసంహరణలో హైకోర్టులో వాడివేడిగా వాదనలు జరిగాయి. కోనసీమ జిల్లాకి అంబేద్కర్ పేరు మార్పును నిరసిస్తూ వేలాది ఉద్యమకారులు కొనసాగించిన మరణకాండపై రాష్ట్ర ప్రభుత్వం కేసుల ఉపసంహరణపై జీవోపై హైకోర్టులో ప్రజా ప్రయోజన వ్యాజ్యం వేసింది. అంబేద్కర్ కోనసీమ జిల్లా సాధన సమితి కన్వీనర్ జంగా బాబురావు హైకోర్టులో వ్యాజ్యం దాఖలు చేశారు. ఇక పిటిషనర్ తరపున వాదనలు వినిపించిన ప్రముఖ న్యాయవాది జడా శ్రవణ్ కుమార్ ఈ వ్యాజ్యాన్ని విచారించిన ప్రధాన న్యాయమూర్తి జస్టిస్ ధీరజ్ సింగ్ ఠాకూర్ మరియు జస్టిస్ రఘునందన్ రావు ధర్మాసనం కేసుల ఉపసంహరణ విషయంలో రాష్ట్ర ప్రభుత్వం జోక్యం ఉండరాదని పబ్లిక్ ప్రాసిక్యూటర్లు స్వతంత్రంగా నిర్ణయం తీసుకోవాలంటూ పిటిషనర్ తరపున వాదనలు వినిపించిన న్యాయవాది జడా శ్రవణ్ కుమార్ కేసులు ఉపసంహరించుకోమని పబ్లిక్ ప్రాసిక్యూటర్లకు ఆదేశాలు ఇవ్వడం, సుప్రీంకోర్టు జడ్జిమెంట్ కి వ్యతిరేకమంటూ వాదనలు అత్యంత హేయమైన కేసులు ఉపసంహరించుకోవడం వల్ల చుట్టం చులకన అయిపోతుందంటూ వాదనలు పిటిషనర్ న్యాయవాది జడా శ్రవణ్ కుమార్ వాదనలతో ఏకీభవించిన ధర్మాసనం ప్రభుత్వ జీవోను అనుసరించి ఇప్పటి వరకు ఏ విధమైన ఉపసంహరణ పిటిషన్ కింద కోర్టులో దాఖలు చేయలేదంటూ ధర్మాసనానికి తెలిపిన ప్రభుత్వ న్యాయవాది.
In issuing the GO is under challenged, my lord.
Or where is the GO?
Page 46, my lord.
Page
46.
46.
The operative post is 47. My lord, directing the public prosecutors or instructing them to withdraw the cases is not permissible under the law.
The government, after careful examination, has decided to withdraw
And he has to take an
prosecution of
independent
6
call.
cases registered against accused. So this is not permissible.
Not permissible.
So who is entitled to then take a decision?
A public prosecutor and the PPs are respective PPs are entitled to take a call independently, examining the facts of the case.
So can we see what is the provision and what
Yes,
is the
my
law?
lord. 212, 321,
Sorry,
321, my lord.
321
Of CRPC.
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 Yes. My lord's permit. The public,
One more.
Let us get hold of the book.
yes,
All right, in the meantime, read.
yes. And Honorable Apex Court, my lord, categorically held in the same subject.
Provision.
Read the provision, then the judgment.
Please read the provision once.
Yeah, provision, I'll read. The provision, my lord, 321, withdrawal of from prosecution. The public prosecutor,
321.
yes, my lord, CRPC.
Yes.
Yes, my lord. The public prosecutor, assistant public prosecutor in charge of a case may, with the consent of the court, at any time before the judgment to pronounced, withdraw from the prosecution of any person, either generally or in respect of any one or more of the offences for which he tried, and upon such withdrawal. If it is made before a charge has been framed, the accused shall be discharged in respect of such offences. It is made after the charge sheet has been framed. When under this code, no charge is required, he shall be acquitted in respect of the such offences. Provided that, my lord, if at all any central government properties are involved, they should get the permission from the central government unless they are not permitted to withdraw. And as my lord, time and again, Honorable Apex Court also held, the public prosecutor has to take an independent call and he cannot be instructed by the district magistrate or the state government to withdraw it. There's a specific, my lord, if my lords kindly see page 212 judgment.
One second.
212 specific, my lord, Honorable Apex Court judgment one
One
moment.
minute.
చెప్పింటావా 30 మార్క్స్ నీకు హిస్టరీ 30 మార్క్స్ ఇస్తే నీకు బాగా వస్తుంది. ఆ తర్వాత జోగ్రఫీ కూడా అంత ఉంటుంది. ఓషన్ నాకు అన్నీ ఎట్లా ఉంటుంది కొన్ని చదువుకు ఏముంది దాంట్లో ఓషన్ టైడ్స్ ఇవన్నీ ఏపీ జియోగ్రఫీ చాలా ఈజీ తెలుసు. పెద్ద టఫ్ ఉంది ఏపీ జియోగ్రఫీ. ఇండియన్ జియోగ్రఫీ ఎకనామిక్ జియోగ్రఫీ చెప్తా కాబట్టి ఎకనామిక్ జియోగ్రఫీ నేర్చుకో.
So these are judgments S.K. Shukla
Yes.
and Rahul Agarwal.
No. Page 210. Jalwant Singh versus State of Bihar.
All right, take down.
This
Subject. In fact, the issue, similar issue, identical issue fell for consideration before the Honorable Apex Court. Just because an initiative has come from the government, it does not vitiate the
But the judgment
Yes.
SK Shukla versus State of Uttar Pradesh,
Yes.
AIR 2006 Supreme
Yes.
Court,
That is also plain.
says that public prosecutor is an officer of the court. He has to act independent,
Yes, media,
and therefore he cannot be expected to go as per the dictats of the
but he has
state
not,
government.
he has not acted upon. But the only thing is that as initiative, it is only tentative decision of the government.
Nothing takes away the right of the public prosecutor.
Yes, Mirad, he has to apply his independent, may circulate the judgment.
No, that is what
Latest-
that is what the judgment says.
Latest judgment.
Now the question is, but to that extent, you can't direct the withdrawal of cases. This
Ah.
appears to be the law.
But the issue, Mirad, an identical issue, Mirad, for consideration before Mirad, the Honorable Apex Court. Mirad, may I draw your kind attention to Mirad, page 21. Mirad, that is bottom, it is indicated, page number. Mirad, I'm sorry, Mirad, in the lawsuit, Mirad, I would able
No,
to.
no, it's okay.
Yes. Mirad, para 23, Mirad, your Lordship.
Para 23.
Yes. So, Mirad, by referring to the line of judgment, so Mirad, the principles are summarized, Mirad, by the Honorable Apex Court. May I read it for your Lordship kind consideration? The principles which emerge from the decision of this court on the withdrawal of the prosecution under section 321 of the CRPC can now be formulated. Section 321 enters the decision to withdraw from the prosecution to the public prosecutor, but the consent of the court is required for withdrawal of the prosecution. The public prosecutor may withdraw from the prosecution not merely on the ground of paucity of evidence, but also to further the broad ends of the public justice. The public prosecutor must formulate an independent opinion before seeking the consent of the court to withdraw from the prosecution. While the mere fact that the initiative has come from the government will not vitiate an application for withdrawal, the court must make an effort to elicit the reasons for withdrawal so as to ensure that the public prosecutor was satisfied that the withdrawal of the prosecution is necessary for good and relevant reasons. In deciding whether the grant consent to the withdrawal, the court exercises the judicial function, but it has been described to be supervisory in nature. Before deciding whether to grant its consent, the court must be satisfied that the function of the public prosecutor has not been improperly exercised, or that it is not an attempt to interfere with the normal course of justice for illegitimate reasons or purposes.
Now, in this particular case, has the public prosecutor filed independent application?
No, so far it is not being withdrawn. Then immediately he has to move an application, he has to apply his independent mind, then move an application. Then the court has to give a consent. Mirad, there are three stages, Mirad.
Now, if everything has to be done by the public prosecutor,
Yes.
then what is the aim of the government order?
No, Mirad, he may be guided by the Mirad, government decision, he may not be guided. Mirad, ultimately, Mirad, that is the reason checks and balances are there. The concerned jurisdictional court has to give a consent for the Mirad, such an application. So that stage has not come, Mirad. But
That
this one
stage has not.
not come. This is only initiative, government decision, tentative decision indicated, Mirad. In fact, in the same judgment, the Honorable Apex Court, Mirad, was pleased to discuss, Mirad, the tone and tenor of the Mirad language employed in the government order. It doesn't, Mirad, in fact, vitiate the Mirad, the GO initiative, Mirad, which has come from the government. No, he can as well, Mirad, suppose if the court gives a consent, he can question that judicial order. Mirad, in consenting for Mirad, the withdrawal, Mirad, moved by the Mirad state. By way of filing, Mirad, revision, Mirad.
But I'm not a party, I don't have any locus to.
No, that is a different aspect.
Unless
But
and
even-
until my lord, the GO goes, he was under influence of the GO, he is under obligation to file it. He
But he
cannot
can't-
independently, my lord, apply. his
Now,
mind.
what were the facts in this case?
But I'll come. to
Yes.
it.
In this one second, in this particular case, also there was a government order.
Yes.
There was no government order in this.
Yes.
There was no government order in this. The
Yes,
public
but let the-
prosecutor himself sought withdrawal.
Yes.
Then that was rejected by the trial court.
Yes.
Government filed an appeal to the High Court, rejected.
Yes.
Then they filed an appeal to the Supreme Court, rejected.
Yes. But
All three places it was rejected.
But Mirad, I am only Mirad, drawing your lordship kind attention about the principles laid down by the Honorable Apex Court. That is what the Honorable Apex Court said, that Just because a initiative has come from the government, it doesn't vitiate the proceedings.
So where is that
Yes.
discussed?
No, that's why Lakshmi can say. Just now, I draw an attention.
So,
Not sub-para, yes.
so in
Sub-para 4.
in what context was the Supreme Court discussing this? In the context of the past judgments?
Yes, Minute.
Huh?
Yes, line of judgment.
Okay, let us go to that para.
Yes. Yes, 1 minute. So in fact, so I was drawing your worship kind attention to the the only principles as laid down by the Honorable Apex Court in the line of judgments.
Page 11, sir.
Yes. What, para 14. The powers under section 322 of the CRPC have been interpreted by this court on a number of occasions. The state of Bihar versus Ram Naresh Pandey, the three-judge bench of this court analyzed section 494 of the earlier code of CRPC. This is another observed that in granting consent to withdraw a prosecution, the court exercises judicial function. However, in doing so, the court need not determine the matter judicially. The court only needs to be satisfied that the executive function of the public prosecutor has not been improperly exercised, or that it has not an attempt to interfere with the normal course of justice for illegitimate reasons or purposes. This court also observed that the magistrate's power under section 494 was to prevent abuse of power of the executive. Addressing the question whether insufficiency evidence is a good ground for withdrawal of the prosecution, I held that. In fact, while line of judgments, even Rajendra Kumar Jain judgment also my learned friend has laid upon, where there also the decision of the government, yes.
Go to page 12, paragraph 16.
Yes.
Rajendra Kumar Jain versus State through Special Police Establishment, 1983 SCC 435.
Yes.
The judgment of some of the passages have been extracted.
Yes, that
Para 17 at page 13.
yes. So under the Code of Criminal Procedure, it is the public prosecutor that has to withdraw from the prosecution, and it is the court that has to give its consent to such withdrawal. It is he that is interested with the task of initiating the proceedings for withdrawal from the prosecution. But where such large and sensitive issues of public policy are, he must, if he is right-minded, seek advice and guidance from the policymakers. His source of information and resources are of very limited nature, unlike those of the policymaker. If the policymakers themselves move in the matter in the first instance, as indeed it is prayed, it is proper that they should, where the matters of momentous public policy are involved, and if they advise the public prosecutor withdraw from the prosecution, it is not for the court to say that the initiative comes from the government, and therefore the public prosecutor cannot be said to have been exercised a free mind, nor can there be any quibbling over the words. If ill-informed but well-meaning bureaucrats choose to use the expression like the public prosecutor is directed or the public prosecutor is instructed, the court will not on that ground alone stultify the larger issue of public policy by refusing its consent on the ground that the public prosecutor did not act as a free agent when he sought withdrawal from the prosecution. What is at stake is not the language of the letter or the prestige of the government, but a wider question of policy. The court in such situation is to make an effort to elicit the reasons for withdrawal